These are appeals in the matter of Epping Forest District Council and Somani Hotels.
Yes. May it please the Court, Edward Brown with Ms Elliott for the Secretary of State, Mr Green and Ms Peter for Epping Forest District Council, Mr Riley Smith for Somani Hotels Ltd. My Lord, turning to housekeeping, the parties have put together a speaking timetable which has been communicated to the Court.
Yes, Miss Elliott's email of yesterday reflects an agreed running order and agreed timetable, and we're very happy with it.
My Lord, I'm grateful. In terms of the bundles before the Court should have the following: a core bundle from the Secretary of State, which I'll refer to as core bundle 1, Somani's core bundle, which I will refer to as core bundle 2, Somani's supplemental bundle, which I'll refer to as supplemental bundle 3, and Epping have applied to file a further supplemental bundle, which I'll refer to as bundle 4. I'm not proposing to address the application of Epping, which they have made in order to rely on additional material at this stage. Does the Court have all of that material?
Yes.
And the Court should also have an authority bundle?
Yes.
With that, my Lord, I propose then to start my submissions.
Yes.
By way of overview, these are appeals against two orders of Mr Justice Eyre made on the 19th of August 2025. Those orders are in core bundle 1 at tabs 4 and 5. The judge refused to allow joinder of the Secretary of State and granted the claimant's application for interim relief. There is a note of the joinder judgment at tab 8 and an approved judgment on the injunction application at tab 9. If I could ask the Court please to turn to the injunction, that is core bundle 1, page 33. The Court will see that the effect of the injunction is set out at paragraph 1 of the order. In essence, it prevents the Bell Hotel Epping being used for accommodating any asylum seeker in any way. That accommodation at that hotel is provided by the Secretary of State to those residents pursuant to a contract with a third-party CTM, who in turn contract with defendant Somani. The Court will immediately see that this is an injunction which operates within the framework of public law. It seeks to enforce a specific public interest, which is the enforcement by Epping of local planning controls for which it is responsible. The Secretary of State says that its consequence is substantially to interfere with another public interest, which is the national public interest in ensuring that vulnerable individuals, namely asylum seekers, are accommodated. My Lord, it's not in dispute that the Bell Hotel currently forms part of a much larger programme for accommodating at short notice a large number of potentially destitute people. At the heart of this appeal are essentially three overarching submissions. The first is that the judge erred in declining to allow the Secretary of State to participate in the proceedings, given her unique institutional competence and her statutory duty to accommodate asylum seekers. The Secretary of State's rights were clearly affected and she ought to have been heard on the application. The second is that the judge erred in holding that there was anything more than a serious issue to be tried on the alleged breaches of planning control, not least having regard to the very limited allegations of planning harm in the Part 8 claim form and the judge's factual conclusions on those allegations.
Slow down for a moment. Yes.
The third of the three overarching submissions is that the judge erred in deciding that the balance of convenience at this interim stage favoured short notice closure of a site forming part of critical national infrastructure, namely the National Programme for Asylum Accommodation. That third submission breaks down into two components. The first is that we say that the consequences of the injunction were not commensurate to the planning harm identified by the judge. And the second is that the judge did not have proper regard to the specific and highly unusual need that arises from the statutory duty to provide accommodation.
Yes.
The consequence, we say, is that both orders were wrong, and we ask for this court to grant permission to appeal, permit intervention, and to discharge the interim injunction. I propose to structure my submissions in 5 parts. They are as follows. First, I'll address the court on the joinder decision. Secondly, I'll address the court on the approach to the interim relief injunction, on the material and evidence that was before the judge. Thirdly, I will address the court on further evidence that was not before the judge in relation to the statutory duty to accommodate potentially destitute asylum seekers. Fourthly, I will address the errors made by the lower court. And fifthly, I will make submissions on the balance of convenience. Returning to the first of my 5 areas, appeal against the joinder decision. The relevant test is CPR Rule 19.2, paragraph 2A. That provides that the court may order a person to be added as a new party if it is desirable to add the new party so that the court can resolve all the matters in dispute in the proceedings. There are 2 principal Court of Appeal authorities, Re Pablo Star, which is Authorities Bundle Tab 8, and a Better Ocean Way, Authorities Bundle Tab 19, which are, broadly speaking, to the same effect. If I can invite the court, please, to turn to Better Ocean Way. It's the most recent statement of principle. Does the court have Better Ocean Way at tab 19?
Yes.
This is an appeal from a decision of the Commercial Court, judgment of Lord Justice Males. Don't need to trouble the court with the specific facts of that commercial dispute. The statements of principle appear beneath a heading at paragraph 35, 356 of the pagination, CPR 19.2, subparagraph 2. The Court of Appeal states the rule at paragraph 35, and at paragraph 36 says the term "the matters in dispute in the proceedings" must be given a wide interpretation in order to ensure that persons whose rights may be affected by the court's decision can be heard when it is desirable that they should be. There is then a lengthy citation from Terence Etherton, the Master of the Rolls, and Pablo Star. And if I could ask the court, please, to read paragraphs 50 through to 53 of Re Pablo Star as cited in Better Ocean Way.
Yes. Should we go on to 37 of
Yes,
this
I'm going-
judgment?
Yes, I'm going to ask the court then to read paragraph 37.
Yeah. Yes.
And then finally, if I may please, paragraph 41, the sentence that begins 8 lines down on paragraph 41, it is hard to envisage circumstances in which the court would conclude that it was desirable to add the new party in order to resolve all the matters in dispute, but would nevertheless decline to do so. My Lord, in our skeleton argument of paragraphs 18 and 19, we refer to other authorities which state principles to similar effect. I'm not proposing to take the court to any further authority on the point. We have referred in paragraph 18 to a specific example which is set out in the White Book, where the decision will impact on the ability of a public body to discharge its statutory functions. That's the Nottinghamshire County Council Bottomley case. That's paragraph 18. In paragraph 19, we referred the court to the specific CPR rule which provides for the joinder of HMRC where there are tax consequences of a dispute. I can state our position simply. Our case is that the Secretary of State's rights, i.e. the statutory duty, are very clearly affected by this interim injunction application, and therefore she ought to have been heard. The judge did not accede to that submission. The judge's judgment is at Core Bundle 1, tab 8.
Yes.
The judge identified 3 issues of paragraph 13, which appears on page 47 of the bundle. One, whether there has been a breach of planning control. 2, whether relief by injunction should be granted. 3, whether preconditions for interim relief are made out. One of the elements that will need to be considered in determining the last point is to take account of the balance of convenience. And certainly before the judge, the submissions which we wish to make were very much directed at the balance of convenience question, namely what would be the impact of injunctive relief on the statutory duty. And paragraph 14 states this is where Mr Brown Casey comes in. He contends that the public interest in the SSHD statutory duty to accommodate is an aspect of the balance of convenience, and so it is. This was not an issue between the parties. And then the judge says the argument that were developed were to the effect that the claimant accepted that the public interest in the housing of asylum seekers is a relevant consideration in the balance. Now that acceptance for what it is by Epping departed very substantially from their skeleton argument. I'll give the court the reference. It's Core Bundle 2, page 76.
Sorry, what, the acceptance, that's in paragraph 14.
Yes, so fifth line down, the claimant, that's Epping, accepted that the public interest in the housing of asylum seekers is a relevant consideration in the balance. And then there's reference to Ipswich, which of course is an authority, and it involves, and we'll look at it, consideration and discussion of the position in 2022. But the Ipswich authority is not, of course, evidence as such. It records the evidence that was before the judge, Mr Justice Holgate, in 2022, but it doesn't have the status of evidence itself.
Yes, then you were going to go to the skeleton.
Yes, the skeleton argument that Epping had lodged before the court, paragraph 74, stated it in terms that the statutory duty should attract no weight. So they said there is nothing on the other side of the balance in respect of balance of convenience. And that the only relevant factors were the planning concerns and the planning harm that Epping had identified.
Could you just remind me where the page is in the second core bundle?
Yes, 76.
Thank you.
If it's helpful to turn to that, it's the paragraph 74 which appears at the bottom of the page.
Got it.
So true it is, there may have been on the part of Epping a departure from the written submissions that they advanced before the judge, which is that the judge ought to give no weight to the statutory duty. But that was done only by reference to the Ipswich case. What the judge did not have was any evidence from the Secretary of State or any argument from the Secretary of State. Now the judge addresses this in paragraph 15 by saying, well, the Secretary of State can provide evidence to another party. And that, of course, is technically correct, but that logic would apply in any case. So any individual can provide evidence to another party without formally applying to join the proceedings. But one does have to have some regard to the practical realities of the specific injunction before the judge. This application came on with no pre-action correspondence, on only 3 clear days' notice in August. That is the practical position. That provided an extremely short window for the steps which the judge considered ought to have been taken. But the central criticism is that it does not grapple with the central complaint that we say the Secretary of State's rights are affected and therefore she ought to be heard. That is fundamentally the question laid down by the authorities. And it is no answer to that to say that you can provide evidence to another party and hope that they will then deploy it in your interests, because that is not giving the Secretary of State the opportunity to be heard. Moreover, simply identifying that there is a public interest in play is not the same as hearing argument as to the weight that should be attached to that public interest. What the judge needed to do was not simply identify the existence of the statutory duty, but to consider in a structured way how that statutory duty is liable to be impacted by the interim relief that was being sought in this case. So with respect, the analysis by reference to the statutory duty is too light because the judge is not asking himself, well, what does that mean in practical terms if I were to grant the relief sought? It's not enough simply to say that it would be impacted. There has to be a proper understanding of the scale of the impact. And that is a point on which I will address the court today.
The short point arising from what you've just been saying is that, yes, of course, another party can provide evidence to one who already has rights and duties before a court, but rarely will they have exactly the same interests.
Yeah, precisely, my lady. Yes, and that's why the power exists. And in circumstances where it is a fundamental duty that's in play, then the court should have been extremely concerned or cautious about proceeding without hearing from the party responsible for that duty. Those are our criticisms on principle. On discretion, I've shown the court paragraph 41 of Better Ocean Way when Lord Justice Mills indicated that it would be hard to imagine circumstances where the gateway question, i.e. desirability, has been satisfied, but it would nevertheless decline to order joinder. That is precisely what occurred here. So the judge further said that even if he were wrong about gateway, because of the allocation of court time, and because of the points in Ms Jones's witness statement, where the Secretary of State explained that she had understood incorrectly that the hearing was being adjourned, therefore counsel had not been instructed and indeed not been able to be instructed, the court concluded that it would have exercised a discretion against allowing joinder. We say that that was not the proper approach, having regard to what Lord Justice Mills says in paragraph 41. If the judge, in fact, had considered it would have been desirable to hear from the Secretary of State, then the judge should have done so. He should have heard from the Secretary of State. We were there and prepared to make those submissions. There is, or was, a discussion about whether that would have required a short adjournment. It is unclear whether that would have required an adjournment, as Epping did in fact make submissions in relation or in response to the Secretary of State's points on balance of convenience, as indeed they do now. But if the price was a short adjournment, we say that that was plainly the right course when the impact of the injunction had the potential to be so significant.
What was the nature of the hearing on the 19th?
It was a hand-down hearing.
The case had been listed for hand-down.
Yes.
And Home Office, Government Legal Department, after the email sent to a former clerk to the judge on Friday, made an application on Monday.
Yes.
Was that listed to be heard at the same time?
Yes. So
in the morning?
No, 2 p.m.
2 p.m. So you all turn up, you make submissions saying, don't hand down the judgment until you've heard.
Yep.
From me, the judge gives the oral judgment, refusing the application, and then hands down the injunction judgment.
That's correct.
Right. Thank you.
Mr Brown, are you at some point going to address us on the difficulty which the judge was placed in by the timing of this application for joinder?
I've indicated the issue identified in the evidence. So it's paragraph 18 of Ms Jones's witness statement provides the explanation.
Yes, I've got to understand that.
So the judge was not in difficulty because the judge had correctly identified that subject to Epping's views, if Epping were not in a position to respond on the 19th, on the Tuesday, then it would require an adjournment. So the judge correctly identified that. Respectfully, that's not a difficulty, that's simply a practical consequence. If there had been cost consequences, there would have been submissions on those points. But the judge was under no other difficulty, save for the point about allocation of court time. And we recognise, of course, the need and importance for procedural rigour. But fundamentally, this is a discretionary question which requires consideration of the interest of justice fundamentally. So the judge may have been right to acknowledge that the events of the previous week were unsatisfactory and that the intervention might have been made earlier.
Do you agree with that?
Yes, I agree that it is unsatisfactory and might have been made earlier. Plainly, that's right. With the benefit of hindsight, when the application was served at some point the previous week, then it could have been responded to. That's clearly right. But I do make the point that there was no pre-action correspondence and it was brought on effectively at short notice. So the window was extremely tight. It was in August. That does, in the real world, present practical difficulties. Could they have been overcome with the benefit of hindsight? Of course they could.
But I think, in fairness to Somani, because they were placed in the same difficulty,
Yes.
there was no pre-action correspondence. There was informal service on the afternoon of the 11th of August, formal service on the 12th. And it might be said it's to their credit they moved and that of their legal advisors as quickly as they did. I mean, everyone was under pressure of time.
My lady, that is absolutely right. I don't intend to seek to improve on the evidence. The evidence, frankly and candidly, sets out the position as to what occurred. The question for the judges, notwithstanding my view as to those procedural events, should I nevertheless have heard the Secretary of State? That is the question the judge ought to have asked. The judge did effectively ask himself that question, but we say erred in the two material respects. First of all, by saying, well, he did not need to hear the Secretary of State, and even if he did, not considering the alternative cause, which in reality would have been a very short-term adjournment, a matter of a day or two.
Well, I think it was canvassed, wasn't it, a couple of days?
Yes, indeed. So Epping had indicated Thursday with the hearing on Tuesday, and of course that would have required an additional allocation of court time, but that is what court time fundamentally is for, to allow hearings to be properly conducted. And I've indicated the position on costs. That could have been factored in to the consideration, and we say perhaps ought to have been part of the overall consideration. So we say that this is a case where the judge fundamentally erred in principle, and those errors essentially did infect the question of discretion, and on either basis then this court ought to set aside that decision and allow joinder not just for the purposes of today, but also of course the substantive hearing, because the consequence of the judge's refusal is that the Secretary of State cannot participate in the October hearing either. And there's no obvious reason as a matter of discretion why the Secretary of State would not be entitled to participate in the proceedings more generally if the judge is wrong about gateway.
Is your application on the procedural side, if the case goes further, to be added as a defendant in the High Court, as an intervenor?
Intervenor.
As an intervenor.
Yes, there's no claim, there's no relief sought against us, so therefore the correct status is intervenor, not defendant.
Yes.
My Lord, that's what I propose to say then on the first of my 5 grounds, the application of joinder, and I propose then to turn to the second, which is the substantive application, the injunction application. And if I may start with the statutory duty, we've summarised the statutory duty of paragraph 11 of our skeleton argument of bundle 1, page 18. Paragraph 11 summarises then the relevant statutory provisions from the Immigration and Asylum Act 1999 and the regulations made under that statute. And if I may simply identify then the purpose of that statutory duty, and that duty ensures that the United Kingdom discharges its obligations under Article 3 of the ECHR in this context to potentially destitute asylum seekers. And the context then is the obligation conferred by Parliament upon the Secretary of State to provide accommodation. and that is accommodation for a large number of vulnerable individuals. And it's our case that that requires a national strategy in order to ensure suitability, minimum standards, and importantly, having regard to matters of fairness. Those responsibilities have been conferred by Parliament for many years on the Secretary of State. We accept that Epping is entitled to say that this specific statutory duty is not one that is conferred upon Epping. But we do say that it would be wrong to treat Epping's role as akin to a private landowner. Epping is a public authority and is part of the structure of public administration in the United Kingdom. And we say, supported by authority which I will show the court, that in its decision-making process, Epping ought to have considered not only the views of residents and elected members, but also the wider consequences of its application on the public interest more generally. My Lord, I propose now to show the court two authorities regarding the jurisdiction in question, which is section 187B of the Town and Country Planning Act 1990, that's South Bucks District Council of Porter, and then the Ipswich decision. If I can turn to South Bucks first, please, that's authorities tab 5.
Yes.
And the facts of South Bucks are that local authorities have sought injunctions against gypsies who were said to be occupying land without the relevant planning permission. And House of Lords ultimately refused to grant the injunctions. If I can make submissions by reference first to Lord Bingham's judgment, at paragraph 10, which appears at page 58, at the bottom of my pagination, the court at paragraph 10 and then paragraph 11 identifies the planning regime in issue, which I would respectfully adopt. And if I can ask the court to read those paragraphs. And then please paragraph 20, where the court sets out and approves 5 paragraphs of the judgment of Lord Justice Simon Brown in the Court of
Yes.
Appeal.
Yes.
My Lord, it is right to note that there is a minor dispute as between the Secretary of State and Epping as to the extent to which the court will determine the planning permission issues for itself. That's identified at paragraph 26(1) of Epping's skeleton argument. We say that's not of significance for today's purposes. That's not an American cyanide question as such. No doubt the court in October will hear detailed submissions as to the extent of the court's jurisdiction to decide whether there has been, in fact, a breach of planning control. Well,
So what will be the issues at the trial in October?
well, my Lord, I've sought to ascertain the answer to that for myself. And our best understanding is that Epping are going to say that the court should, by way of declaration, decide the question of planning permission, whether planning permission is required or not, whether there has been a material change of use.
Yes.
And if so, the court will then decide the question of final injunctive relief, which may of course be time-limited final injunctive relief. That is my best understanding. But I understand there to be a disagreement from Somani as to whether in fact that question, i.e. the planning merits question, is in fact proper to that judge.
Well, forgive me for interrupting my learned friend, but I do need to know the case I have to meet, whether grounds of appeal are no longer being pursued. Paragraph 35 of my learned friend's skeleton argument. A number of criticisms are made of the judgment below. And the first one is that the judge approached the balance of convenience exercise on the basis that the court would have to reach a view on the lawfulness or otherwise of the use of the hotel. The council's case that the use of the hotel to accommodate asylum seekers is unlawful.
Yes.
And I think it's being said by the Secretary of State that that's not an issue actually for the court to determine. We say that's just plainly wrong. And I need to know, for my own purposes, if that's an allegation that's still being advanced or not.
I can provide that clarification. We say that the error is that the judge ought to have simply identified serious issue to be tried and left it at that. The judge was not in a position and ought not to, in this case, have said in respect of balance of convenience that Epping has a particularly strong case on planning permission. That's entirely consistent with our single ground of appeal, which is that the court was wrong in its approach to balance of convenience.
But going back to the question of what the issues will be at the trial, the court will surely have to decide the threshold question of whether planning permission is required. I see a nod from Mr. Cobb, at least I understand that. If planning permission is not required, then the court isn't making a judgment on the merits of the application. That's, as I understand, is contentious, but the hotel versus hostel issue of law considered by Mr Justice Holgate in numerous cases as to whether planning permission is required at all, that is an issue of law which will have to be decided at the trial.
There's different ways the judge could approach it, though. So the judge could certainly conclude that there has been no material change of use, in which case the basis for the injunction would appear to fall away entirely. The extent to which the judge can reach opposite conclusions is, I think, a matter of some debate and would require submission, having regard to what's said in paragraph 20 about the judge not deciding the questions of planning control, so or the planning merits of the case, as it's put in paragraph 20 of Porter. Now, I take my Lord's point. There is going to have to be, presumably, sufficient consideration of that question in order to determine the question of final injunctive relief. For present purposes, those are arguments that can be properly left to that judge at that term date hearing. I don't wish to say anything which essentially interferes with arguments that are not before this court today. Whilst we have the judgment open, if I can ask the court to turn please to paragraph 99. This is in Lord Scott's judgment.
Sorry, we're back in Porter.
Yes, back in Porter, please.
29?
No, 99, which is
90.
page 90.
Yes.
If I can ask the court to read, please, 99 through to 102.
Yes.
What we say, consistently with the approach adopted by the courts in the full range of American sign and injunctions, is that the right approach is to have regard to all of the circumstances, by which the court means the properly evidenced circumstances before it. Where there is impact on another public interest, there should be proper regard to that. In the specific context of planning injunctions, regard should be had to steps taken to date within the planning regime, so what has already happened within the context of the planning regime. And that requires evaluation of both parties, so both the local authority, what steps have they taken within the planning regime, and also the landowner. Has there been breaches? And if so, there should be consideration of the degree and flagrancy of the breaches, which essentially means the extent to which the development breaches planning controls. And all of that should take place in a structured way.
I think Mr. Riley Smith is going to deal with deliberate breach,
Yes,
vagrancy, and so on.
I will say something about it.
Yes.
If I miss anything, Mr. Riley Smith will say something
Yes.
in order to supplement that. Good to turn now to Ipswich.
Yes.
Forgive me, my lord, may I just interrupt again? I appreciate I'm disturbing my own friend's flow, but I do need to know what grounds are being advanced. And one of them is that the judge made a clear error of law, it said, in saying that the court would have to determine the lawfulness of the use enforced against. Paragraph 35 from the Lone Friends Code of Argument. Is that being maintained or not?
Well, I hope I've addressed the court on what Secretary's case is. We say that the relevant question is the error based upon the strength of the case in terms of serious issue to be tried, which then feeds into balance of convenience. I do not see that Epping has any lack of clarity on that point. If they say that there's another point which is of particular relevance by reference to what's going to happen in October, then they can use their time to make those submissions, but I propose to move on to the Ipswich case now.
Then I'll have to address the point in my
Ipswich, my lord, is authorities tab 22.
Well, just before we leave this, looking at paragraph 35 of your schema, Mr Brown, you say it seems to me it may be too compressed. The court is not entitled to form such a witnesses at trial on the lawfulness or otherwise of the use of the hotel as asylum accommodation before granting a final injunction. That seems to me not to distinguish between what I understand to be two separate issues. A, whether planning permission is required at all, which seems to me subject to anything you may say is absolutely an issue for the judge at a trial. But secondly, if it is required, then the planning merits issue, which it may not be for the judge at trial to form his own view.
Yes, my lord, I see that distinction, and that is something we will reflect on. But I stand by the submission that that is fundamentally a submission for the trial. The criticism here is how it feeds into balance of convenience. Now, the judge has, we say respectfully, gone too far in this case in his evaluation of the planning merits of the case. Now, as to whether there will be a final determination, I note what my Lord Justice has been indicates, but we do say that that will be the subject of detailed further argument, having regard to the complexity of the judgments in Porter.
That's a different point. I understand that you're saying that the judge went too far in deciding the strength or otherwise of the claimant's case at trial.
Yes.
That's a different point.
Yeah.
I was asking about what issues will be for the trial judge
Yes.
to determine.
And my primary submission is that it is more appropriate for that to be dealt with at the trial judge, and I appreciate that doesn't answer the court's direct question. But in circumstances where it is not relevant to our arguments on balance of convenience, I do say there is some real force in leaving those arguments over for detailed submissions at the appropriate time, because the Secretary of State making a concession now that that is in fact something that will be for the trial judge may well prove problematic. And it's not appropriate or necessary, but I note the court's view on it, but it's not going to be of assistance in determining this appeal.
Right.
My Lord, I'll turn, if I may please, to Ipswich.
Yes.
Tab 15 at page 220. In Ipswich, my Lord, two applications before Mr Justice Holgate. Injunctions have been made on an interim basis, fact ex parte, by Mr Justice Jacobs, and these were therefore return date hearings. The judgment appears from 223. The judge at paragraph 2 identifies a statutory duty, which I've identified to this court. At paragraph 5, the judge identified that the planning dispute was largely the same as in the present dispute, namely use of hotels to accommodate asylum seekers. There is a section under the heading Accommodation under the Asylum Support System, paragraphs 21 to 29, and that sets out detailed evidence as it stood in 2022 regarding the need to house asylum seekers. And it is right to acknowledge that, broadly speaking, the contingency accommodation arrangements, i.e. the use of hotels as a contingency, remains the case today. It is not the priority or primary use, and indeed it's the position of the government that hotel accommodation is not appropriate. But as in 2022, it is used as a contingent accommodation, and I'll show the court the witness statement evidence in due course. The judge, I won't ask the court to read it, but 30 to 39 is a very detailed consideration of the planning history and the interaction with the Home Office in the specific case. And then if I can ask the court to look please at legal principles at page 232, material change of use. Paragraph 68 identifies the legal obligation, namely planning permission required for carrying out the development. And development in this context means material change of use, or material change in use. (69 to 71) sets out the operation of the use classes, namely that change to a different use should not itself be treated as material.
Sorry, I'm behind you.
My lord,
did you say 72?
Yes, so I indicated that 69 to 71 simply provides background. In the interest of time, I won't go through all the detailed use class provisions that they're set out in clear terms at 69 to 71, but I will make submissions on 72 and 73, which appears under the heading Hotels and Hostel Use. The judge correctly identifies that there is, in the case law, a debate about where the line should be drawn between hotel and hostel use. There's guidance in numerous authorities. But it is finely balanced and fact sensitive. The reference to Mr Justice Glidewell in one case saying that the hotel may lawfully be occupied by permanent residents. And then addressing characteristics of a hostel at paragraph 74. It's not a term of art. Perhaps inevitably it requires a multifactorial evaluation of all of the circumstances, and one will be guided by the cases. However, given that there is a very clear and close factual analogy between Ipswich and the related cases decided around the same time, Fenland and Great Yarmouth, it is notable to see how the judge approaches the matter. The paragraph 81 judge indicates certain factors which might tend to point towards a hostile use. The judge expresses some concern about some of those factors in the context of hotels being used for this purpose, i.e. as asylum accommodation. And ultimately, where the judge ends up at paragraph 101 is to say the starting point is the distinction between hotel and hostel use in the case of the present kind is fine. Some factors pointing in favour of hostel, some factors pointing in favour of hotel. As it's arguable that there is a breach, i.e. hostile use outweighs factors pointing against. But we say it is notable that Mr Justice Holgate, a highly experienced planning judge, did not reach a conclusion any firmer than that, namely that it was arguable, i.e. serious issue to be tried. And we say, given the very clear similarities with the present case, a similar approach ought to have been taken in this case.
Sorry, where is Mr Justice Holgate's conclusion?
Well, the conclusion is 101 triable issue. So one sees that it's effectively being considered by reference to serious issue to be tried. One sees at 103 triable issue. The judge doesn't then do what the judge in this case did, which is then revisit the matter under balance of convenience and consider whether, on American cyanamide principles, it's a case where the issue is so strong or so obviously, conspicuously powerful that it should also be brought into bear on balance of convenience. We say that the right approach is the conclusion reached in Ipswich, namely that there is a serious issue to be tried, but no more. I need to go back slightly.
Forgive me, my lord, I apologise yet again for getting to my feet, but this is not a point that appears in my own friend's skeleton argument.
Mr Cobb, I think we should let Mr Brown get on with this case. Yes.
My lord, going slightly back in Ipswich just because of the theme of the submissions, that's a conclusion as to how to approach serious issue to be tried. There's a section at paragraph 84 of the judgment of 235, which is headed Enforcement Action.
Yes.
And broadly speaking, the judge identifies that in the context of a planning injunction of this sort, the local authority must determine on rational public law grounds that enforcement action is expedient. That's a synthesis of the point under enforcement action. And the point that the judge makes is that it is important then to have regard to the local authority's legal assessment of the expediency of the steps it proposes to take. And I make the point that that is not the same as the expression of political will which is expressed in a motion by councillors. They are two distinct things. The council motion expresses the political will of the local authority. The legal decision is a separate question which requires an evaluation of expediency. We'll return to the question of consideration by Epping in due course. paragraph 98, please, under the heading whether the injunction should be continued. Triable issue. So again, this is focusing on serious issue to be tried. The court at 99 correctly identifies that the pleadings matter here. The key question is what the pleaded change actually is. And I will show the court the three factors pleaded by Epping in its claim form in a moment. Then on balance of convenience, please, this appears at paragraph 108. The starting point is said to be, is it a serious and flagrant breach of planning control? And the judge concludes that it is not in that case, as indeed is the conclusion of the court in this case. No, 111, the judge carefully considers what we would say are conventional American Sinamid principles, what the consequence of the particular relief is. So why does there need to be an interim injunction today? Why can this not wait for October or some other form of enforcement? One has to have regard to the specific relief that is being sought. Here, urgent interim relief requiring closure within 14 days. Then one has to ask whether that is commensurate with the planning harm that is identified. That is the right approach. (114), the court has regard to the different public interests. Of course, there is a public interest in the enforcement of breaches of planning control, but there's also a public interest in allowing the planning system simply to follow its ordinary course. And in this context, therefore, the court should consider whether these matters are better left to the ordinary process of planning enforcement. So therefore, the real question, as it's described in 114, is the strength of the public interest in an immediate injunction before the alleged breach of planning control even begins. Epping correctly identifies that there is a distinction in circumstances where they say the planning harm, in fact, has already begun.
What's meant there by before an alleged breach of planning control even begins?
Well, the court will see that in this case, as in our case, in the Epping case, as in the Ipswich case, there's dialogue between the parties prior to use. And here that's evidence, namely that it goes as far as there being an agreement between Epping, the Home Office, and the contractor as to the number of service users that will be accommodated. I'll show the court some of that material. So we say that in the Ipswich case, as in the present case, the parties are open and transparent because they enter into dialogue with the local authorities as to the proposed use. That is very clearly evidenced. And then that allows for ventilation of the points that the local authority wishes to make. What we say is very conspicuous in the present case is that even though that process occurred here, what ultimately happens is an injunction being served with no pre-action correspondence. So an injunction application being served.
Well, no doubt you're going to address it. There are, if you like, two separate stages. There was that consultation process, which you've already spoken of,
Yeah.
where it appears to be described as a tripartite discussion between Epping, the Home Office, and the designated providers.
Yes.
And then there is the letter of 15th of May 2025, following which Epping could have been in no doubt of the position.
Indeed, yes. So we say that in circumstances where use of the Bell Hotel as a assignment accommodation in fact dates back to 2020, there has been no doubt about this use for many, many years. But the specific 2025 use, as my lady identifies, It's been very clearly flagged, and there's been appropriate dialogue as a result. So in answer to my Lord or Justice's question, then it is of course possible to do all of this sooner. Here, the local authority did not.
No, I understand that. All I was asking, what Mr Justice Holgate was referring to, by saying before an alleged breach of planning control even begins, I thought these were cases where there were asylum seekers being housed at the Nave Hotel, Ipswich, and whatever the hotel in the East Riding of Yorkshire was, before the proceedings were instituted.
Yes, well, it appears that he has in mind either possibility that there could be the situation where the injunction is sought before the breach has occurred. But my Lord is right insofar as the facts of this case are concerned, that there is such use. So it's not entirely clear whether he means something different than the hypothetical possibility that the court should consider the real question, namely the public interest, either before the breach or when the breach has started. It doesn't really matter which. It's the same approach in either situation. So the conclusion at 117, no flagrancy of the breach. We say, noting no flagrancy, that essentially the judge is saying there is a legitimate debate which is not answered by the authorities as to precisely where the dividing line should be drawn between hotel and hostel. That is particularly acute or clear in circumstances where the use of the premises is to accommodate asylum seekers. And the fact of this reported case in 2022 and the other cases which Mr Justice Holgate determined around the same time provides strong support to the submission that the question of use of hotels to accommodate asylum seekers has not produced a clear answer in planning terms. And there are no distinguishing features in relation to the Bell Hotel, which suggests that the position is conspicuously stronger either way. Broadly speaking, it's the same exclusivity arrangements, it's the same short-term contingency use, food is provided. To all intents and purposes, there is a very strong similarity with these authorities, and that should have provided the judge with a strong steer that this is not something which has resulted in an authoritative determination on the authorities.
Well, there had been an authoritative decision binding on him, because he would have to follow it. But he says correctly that the result is not the same in every case.
Yes.
You say he should have stopped there, but you're using Ipswich as a comparator.
Yeah.
So you say if he wasn't going to stop there and was going to consider the strength of the case beyond serious question to be tried either way, then he should have treated Ipswich as a comparator.
He should have, yes. And if he had done so, he would have recognised that it is an exceptional case, see American Cyanamid, where one considers the merits at the balance of convenience stage. That's the reason why it's a three-part test, broadly speaking, that one considers serious issue to be tried, largely independently from balance of convenience, not inevitably. There will be cases where it's so obvious you just don't need to. Or there will be other cases, and we give an example of risk of violation of Article 3, where balance of convenience will essentially have nothing to add to the question. It simply cannot be countenanced. The correct approach here, given that it is finely balanced, should have been simply to say there is a serious issue to be tried and leave it at that.
Well, if the answer is obvious. There's no serious question to be tried. I mean, that's elementary. The serious question to be tried means at trial, the claimant might win, the defendant might win.
Yes.
If it's clear beyond argument the claimant is going to win, or for that matter, clear beyond argument the claimant has no real prospect of success, then the inquiry stops at stage 1. But it's not suggested that this is such a case.
It's not suggested that.
That this is such a case.
But it's so obvious that, no, it's not. So in a sense, the spectrum for these purposes has perhaps 3 components. There's the ordinary serious issue to be tried, so leaving aside hopeless cases, serious issue to be tried. Then there is a spectrum of cases where it appears to be conspicuously strong, but not absolutely clear. The judge appears to have placed it in that category. And then there's my lord's further category, which is when it does not allow for any doubt, contractual interpretation point where there's no argument, for example, about enforceability. It's not just a serious issue to be tried. The court can simply grasp the net and decide it. It's not that category. We say it's the ordinary serious issue to be tried category. The judge places it into a higher category where the judge essentially says it's a very strong case. Where does that affect? On balance,
It seems to have said it was an exceptional case because it was one where both Mr. Coppell and Mr. Riley-Smith were saying, my client's case is so strong that you can, on one side, grant an injunction because the case is unanswerable, or on the other side, they should refuse an injunction because the case is hopeless.
yes, and the Secretary of State, had we been there, would have said, actually, perfectly obvious that this is simply serious issue to be tried simpliciter, as it were. And that's how we put it in Ms. Jones's witness statement.
Anything else from
Yes.
Ipswich?
121 to 127, which is important. Because it's the weight placed on the statutory duty. So, impact on the individual asylum seekers in the first instance. This is accommodation which is being used by those asylum seekers effectively as their home for that period. That is an important consideration. And of course, as is put in 121, final sentence, the statutory duty of the SSHD to provide accommodation for destitute asylum seekers who would otherwise be homeless. Paragraph 123 is a very careful and nuanced evaluation of the pressure facing the Home Office to provide emergency accommodation, and as matters stand, there is no sign of this abating. And the judge, final sentence, 123, it can be seen from the evidence that without such facilities, there is a real risk of some asylum seekers being homeless. And the judge, Justice Holgate 124, is acutely conscious of the practical consequences of this sort of injunction in the real world. In reality, if either or both of the injunctions were to be continued, the Home Office would have to look for accommodation elsewhere. It is clear from the evidence that it is difficult to secure hotels suitable for single-use contracts. The supply is limited. In addition, the process involved takes several weeks. The court is not in a position to draw conclusions on the scope for alternative accommodation to be provided, but bearing in mind a very large and rapid increase in the requirement for accommodation.
Don't read it out, Mr. Brown. We've got limited time.
My Lord, in which case can I ask the court to read 124, 125, 126, 127.
What is IA? Interim accommodation?
Yes.
Yes.
Then, in terms of application, obviously, this the facts of the individual case are matters for the judge determining that application. But if I can ask you, please, to look at the final sentence of 133, the judge concludes no case of substantial planning harm. And 133. The court does have regard to status quo, and I make submissions on that in due course. But the judge correctly identifies, if I may just read this final sentence out, the use of the hotel forms only part of a much larger programme, accommodating at short notice a large number of asylum seekers. The injunction would interfere with the implementation of part of that programme already being undertaken. And that reflects some of the observations that the deputy judge in the Epsom and Ewell case had reached in relation to injunctions against sites being used for gypsy accommodation. They said called to it, but the judge correctly identified that one can't look at this in terms of the individual impact without looking at the wider cumulative effect of injunctive relief, because it is perfectly obvious that if others start to apply for the same injunctions, then that critical part of the national infrastructure is undermined. So chipping away is as problematic. That's precisely what has occurred here.
And taking up paragraph 133, the judge in this case, did he not, acknowledge the public interest in ensuring the proper provision of accommodation for destitute or potentially destitute asylum seekers?
Yes.
And so, in a sense, his views correspond entirely with what is said in the final sentence of paragraph 133.
Well, the judge doesn't address the specific point, because one of the points that Epping is going to address you on is, well, Home Secretary has not told you where else she might accommodate people or what other sites might be brought into service. And the point that was made below is to what extent Crown land could be requisitioned in order to open up new sites. That's not the point. The point is that this is part of the functioning programme, and this then prevents that part of the programme being used in circumstances where the evidence is that the entirety of this data is needed. And the judge in this case does not grapple with that point, so it's done specifically by reference to the Bell Hotel, but without acknowledgement of the fact that that is part of a wider programme.
And so had the Secretary of State had the opportunity to make representations, she would have been able, you say, to address the judge on the operational and strategic implications of the duties that she has under the 1999 Act.
Absolutely, my lord. And the Secretary of State would have said two things. First of all, this specific site is viewed to be suitable and is in use. That's the first point. But moreover, this specific site forms part of a wider programme, and indeed that wider programme to some extent has a lot of similar characteristics. One has to have regard to the fact that the localised approach simply does not have regard to the consequences elsewhere, as it might do in the analogous situation of gypsy premises, in particular local authorities. The question is, well, the individuals still need to be accommodated, so where are they going to be accommodated if this short-term injunction is granted? That's fundamentally what is at the heart of this. And Epping ought to have had regard to that. The Secretary of State had been present. The Secretary of State would have explained that that is a critical and potentially decisive feature, ultimately a matter for the judge, but certainly a very, very weighty feature in the analysis.
We're still on your point 2.
We are.
Approach to interim relief on the material that was before the judge, and then you will come on to further evidence on statutory duty.
So I'll indicate what I'm going to do now, which is very briefly then identify what the planning harms are that the judge effectively considered to justify the relief. That won't take very long. I will then move on to my... Well, I'll very briefly deal with the issue of conduct, both on the part of Somani and on the part of Epping. Then it will be my third area, which is the witness statements of Ms Jones, which I anticipate the court has already read, and therefore I can
Yes.
shortly. So I'm within my time estimate.
Right, keep going.
In terms then of the planning harm, one has to have regard to the pleading. That's the Part 8 claim form, for Bundle 2, page 48. We'll have that at page 12.
Yes.
One sees then that the claim form effectively identifies 3 factors which are said to amount to planning harm or material change in use. And what I'll do is identify those in the claim form and then identify what the judge says about them, where it is in the judgment. So the points are as follows. The first is 1. Occupants of asylum accommodation are or may be vulnerable with a higher incidence of mental health and safeguarding needs and typically have greater need to call on local services such as GP surgeries than the occupants of a hotel. Judge identified that in paragraph 22, saying that was not pressed by Epping and no weight should be attached to it. The second planning harm factor identified by Epping was the assertion of alleged greater propensity to criminal violence arising from traumatic experiences as asylum seekers. That was addressed by the judge at paragraph 75, but in a very different way, because it was addressed by reference to perception or fear of crime. I'll just very briefly show the court that, please. So it's for Bundle 1, page 71, within the judgment.
Right. Page.
So it's page 71 of the core bundle and paragraph 75 of the judge's judgment. So the pleaded case, which the witness statement for the Home Secretary says is unevidenced, and respectfully she is correct to say that. Epping's case is that there is in fact greater propensity to a crime. It's then addressed in what we say is a different way, which is fear of crime. And there's reference to the West Midlands case there in paragraph 75, which was a case concerning a bail hostel. And in those circumstances, the court, perhaps unsurprisingly, considered that there could be evidence that premises which are being used to provide accommodation for people charged with serious crime, such that they are required to live in a bail hostel, or who have been released on conditions that they live in a bail hostel, could be a relevant factor. But all of those accommodated individuals have been charged or convicted of serious criminal offences. And that is self-evidently different from the instant case, where asylum seekers are accommodated because of risk of destitution, not because of criminal wrongdoing. We say that it's an inherently different starting point. And in substance, the judge was right to be cautious in terms of Epping's assertion that there is a greater propensity to antisocial or criminal behaviour. There is no evidence for the court to that effect. The unpleaded fear of crime point was evidenced, but the judge, we say, should have adopted an even more intense level of scrutiny in circumstances where that fear arises from a very small number of specific incidents which are acknowledged to be serious, as opposed to any rational view that the individuals accommodated in general terms have a propensity to criminal activity. That is not a conclusion that can or should have been reached at all, and indeed is not one which we say Epping was in a position to advance, given its limited institutional knowledge on those questions of criminal wrongdoing. That was the second of Epping's 3 points. The third of Epping's 3 points, as identified in the claim form, was what is described as the use of the Bell Hotels assignment accommodation has had and will have the effect of increasing tensions in the local community. And the evidence indeed does demonstrate that there have been protests at the Bell Hotel, and the judge addressed this at paragraphs 70 through to 74. We say the judge was right, paragraph 71, to say that considerable caution is needed before any weight is to be attached to this. Protests are a consequence of living in a free society, and we are all obliged to put up with a degree of perceived nuisance. But the conclusion reached at paragraph 72, we say, is extremely difficult to follow, because the judge appears to distinguish between protest where the hotel hypothetically is being used consistently with its planning permission, and protests where hypothetically the hotel is not being used consistently with its planning permission. We say it's not clear why that makes any difference at all. The protests are not realistically about the planning permission status of the hotel, but they are driven by a range of grievances, and they include animosity towards asylum seekers. So we say that in the real world it's not realistic to think that the objective of the protest is compliance with the planning regime, such that the question of lawfulness of the use has any bearing on the point. But our submission is perhaps more fundamental. Protest is very common in the planning sector. One sees it in terms of environmental impact. One sees it in sorts of a wide range of other uses or proposed uses. The usual and appropriate course is to manage protest. and not use the fact of protest and inconvenience arising from protest as a means of effectively forcing the planning determination. Standing back then on the evidence, the pleading and the evidence do matter. The first factor relied on regarding use of GP surgeries has no weight. The second, in relation to fear of crime, is unpleaded, but is expressly stated to have limited weight.
By the judge.
Yes, by the judge.
Yes.
And third, limited weight attributed to protest, but for reasons which we say respectfully do not withstand rational scrutiny, when it has been acknowledged that protests are a consequence of living in a free society. So the correct evaluation ought to have been that the planning harm identified was weak, even before evaluating the countervailing considerations. What appears in truth to have driven the judge's conclusions are the observations about conduct. And broadly speaking, the judge appears to have formed the view that Somani ought to have sought planning permission at an earlier stage, and that appears to have then, we say, infected or interfered with the evaluation as to the overall balance of convenience. Somani set this out in some detail at paragraphs 42 to 55 of their skeleton argument, which is at core 2, page 20. And I simply highlight what Somani correctly says, which is the judge identified that they acted in good faith. So having concluded that Somani acted in good faith and there was no flagrancy, the issue of conduct added nothing on the findings, but it featured throughout the judge's analysis in apparently critical terms. And when I identify the specific errors, I'll identify those paragraphs. But we say it is completely normal for a landowner to take a different view from a local authority as to the need for planning permission. There is no presumption that the local authority's view is legally correct. It is merely a view. When one contrasts the position of Somani with that of Epping itself, we say the position becomes very clear. Now the judgment, paragraph 8, whole bundle, page 52, please. Goes through the history of use of the bell for these purposes. It has long since ceased to be used as a venue for marriages and private functions. From May 2020, it is being used for the purpose of accommodating homeless people, including asylum seekers. You see paragraph 8. Then correspondence. Paragraph 9, history of the correspondence. With July 2020, John Ayres, a planning enforcement officer of Epping, contacted Somani, said that Epping believed that there was a change of use. Somani said that they did not accept that. So that was 5 years ago. No action taken. Paragraph 10, then opened again in November 2022. So I contacted in November 2022 following He started the exercise to accommodate from October 2022. And there was an application made by Somani for change of use. It was made in February 2023. The statutory regime requires that ordinarily to be determined within 8 weeks. No action was taken by Epping to decide that for 13 months. Then, from paragraph 12, again, discussions between both the claimant, the defendant, and indeed the Home Office regarding use from April 2025.
Were the concerns described in paragraph 11 of the council ever communicated in writing?
I believe the answer is yes. In order to provide the court with a specific reference, I'll have to do that later. Certainly there are a lot of written exchanges. If I can just show you one of those written exchanges, or a note of what has been discussed. So supplemental bundle 3, please, at 373. Now, if the court, my Lord Logistine has the hard copy, I'm afraid I'm going to have to identify this in a different way. So at the bottom it has the pagination SB1644.
This is the...
This is supplemental bundle.
Yes, we have everything other than the 1200-page exhibit in hard copy.
Yes.
Yeah, so this is 1644.
Yes, so in the electronic bundle it's 373.
And this is the exhibit. I'm not going to name the person to the statement,
Correct.
which is the main defence witness statement.
Yes, my lady.
And this is an exhibit which comes from service providers.
Yes, that's precisely right. So it's a helpful summary of the state of affairs as discussed. Does my Lord Logistine have the document?
Yes, I do.
So questions and answers, maybe suggesting that this is actually not the position. So as of the date of the hearing, there are 138 service users accommodated. This is the maximum number that we agreed with Epping Forest Council in tripartite discussions between Home Office, CTM and the Council prior to contracting the hotel for this purpose. I make the obvious point that this is a state of affairs that's been agreed and parties have entered into contracts on the basis of that.
Do we know when it was agreed?
Well, we can date it roughly to pre-April 2025. I'll have to... Somani will be able to identify the specific date. There is the next document in this exhibit is in fact the contract, so that may.
Yeah.
Yeah. So the contract, which one sees at 1647, commenced on the 24th of March 2025. So it must be prior to the date of that contract. So the agreement then is for use as temporary contingency accommodation, could range for a few weeks, could lead to a few months due to backlogs, housing shortages, etc. And there's requests about other use, so the national programme, and it is correctly identified that there is this is the bottom of the page at 1644, there is a shortage. Dispersal can have an impact on mental health, impact on community, safety, could aid in national widespread concerns, it moves the problem elsewhere, individuals need to form new relationships, could impact on risk factors, etc. then some additional points, but I don't propose to make submissions on that. But we say that the inference that the court ought to have drawn in these circumstances is that there was not, in fact, a significant planning concern that had been identified by the local authority. In fact, it appears to be an application which was made by reference to the resolution of the councillors, which they are entitled to pass, but which was broadly speaking triggered by protests and the arrests in the individual cases. There's a particular unique set of circumstances that had arisen, and that is acknowledged. But this strongly indicates that this was not, in fact, a long-standing concern as to planning irregularities on the part of the local authority, as evidenced by the fact that they did nothing for 5 years. So the court should then have had regard to the fact that the planning harm was very specific in its nature, and should then have considered whether this sort of injunction requiring closure on the basis of alleged breach of planning permission was the appropriate response, i.e. was it commensurate to that very specific alleged planning harm. And if the court had adopted that approach, the conclusion on the structural analysis would have been clear, even before considering the statutory duty. So that is the end of my second of 5 areas. That's material the judge had before him, and the conclusions the judge reached even before the Secretary of State intervening. And then the third area of 5 is, well, what does the Secretary of State bring to the analysis? And the answer to that is the witness statement of Becca Jones. That's core bundle 1, tab 7. Witness statement from the Director of Asylum Support at the Home Office. Plainly a witness with very significant subject matter specialism in this area. The court's read the statement. I'll simply highlight the passages which we particularly emphasise then. Paragraph 6, current numbers.
Just let me get there.
Sorry, Madam.
Sorry, my fault. Can you give me the page reference?
Yes, of course. It's core bundle 1, tab 7, page 39. My Lord, I've identified the witness, Becca Jones, her role within the Home Office. Paragraph 6, she provides up-to-date information as to the scale of the duty, i.e. the very large numbers of potentially destitute individuals whom the Secretary of State will accommodate. Challenge faced by the Secretary of State and the Home Office is then identifying suitable accommodation. See paragraph 9. The the witness says that also includes carefully considering the impact on local areas. Support for that is found in the evidence of dialogue with the local authority. Paragraph 11 addresses the question of security checks. There is consideration and assessment of potential risk, as one would expect. There is a programme to address that by way of induction. See paragraph 12. And again, as one would expect, there are prescriptive procedures in place if incidents occur. It is, of course, impossible to exclude the possibility of criminal wrongdoing. One can simply put in place steps to mitigate against it. And turning to paragraph 19, please need to use the hotel accommodation in the present and going forward. The witness explains that if the injunction is to be granted, the Home Office would face considerable difficulties in reaccommodating individuals appropriately in accordance with their statutory duty. There would be a need to place them in other existing accommodation available to asylum seekers at a time of significant and sustained pressure in the accommodation estate. Paragraph 20, the availability of the hotel is also important, enabling the Secretary of State to meet their duty to accommodate future asylum seekers going forward in circumstances where the pressure on available properties is significant and increasing. And the witness says that even in this specific individual injunction, before one looks at cumulative impact of other injunctions, the loss of 152 bed space is significant when considering the Home Office's legal duty. And if I can ask the court to consider paragraph 25, responses to the planning harms that have been identified by Epping. Enhanced vulnerabilities was not pushed by Epping. The propensity to antisocial and criminal behaviour is not accepted. And public protest is acknowledged, but the current position appears to be one of managed peaceful protest. The witness makes the point in the final sentence of 25 that this is an operational matter which takes into account knowledge and experience of what is needed to carry out the Secretary of State's obligations from an overall national and strategic perspective. In 26, the evidence from the witness's professional judgment is that this interim injunction risks setting a precedent which could have a serious impact on the Secretary of State's ability to house vulnerable people, whether it's through injunctions from others or from public protest. And the witness is entitled to express that professional view. That's my third of 5 areas.
Yes.
Fourth of 5 errors made by the lower court. I'm going to summarise the areas which I've identified over the course of my submissions and identify where they are in the judgment. They're all essentially aspects of one criticism, that urgent injunctive relief was not commensurate to the planning harm identified. Point 1, we say the case on material change of use was not higher than serious issue to be tried, and therefore the judge erred at paragraph 103 of the judgment in thinking that it was. I've addressed the court on the reasons for that, and I don't propose to repeat those unless...
No.
Second point is that the court erred in thinking that Somani acted deliberately or impermissibly took a stand. And we say that the analysis that appears in paragraphs 59 to 60, 65, 68, 81 and 107 regarding this point were erroneous.
This is deliberate.
Deliberate, yes. It plainly acted deliberately, but the judge appears to have interpreted or treated the deliberate point as being objectionable. So the court says not flagrant, but is deliberate. If it's deliberate, the question is, well, is that deliberate in some pejorative sense, or is that just a statement of what Somani was actually deciding to do? Because if it's the latter, that has no bearing on the issue of balance of convenience. But it appears to have been used in a pejorative sense because it is repeatedly used as being a factor which effectively counts against Somani's arguments on balance of convenience. Third complaint is that the court erred in failing to have regard to Epping's own failure to act since 2000. That's paragraph 85. My lady's point about the correspondence that has taken place in 2025. Even in 2025, there's a 3-month delay. And the appropriate inference should have been then that the planning permission concern was not in fact the objective, but it was rather a political concern arising from a wide range of different disparate factors. And that is a fundamentally different thing. Fourth, the court erred in failing to have regard to Epping's own lack of consideration of both the individual and cumulative impact of the injunction. There was no real consideration of the effect on vulnerable asylum seekers beyond the fact that they were registered at GP surgeries. There's no contemporaneous evidence of any consideration by Epping as to the expediency of the steps it sought to take. Epping said, in terms of its skeleton argument, the statutory duty should attract no weight, and it certainly did not consider the displacement consequences of this injunction. Where would the individuals be accommodated? What would be the impact on neighbouring local authorities or other local authorities? Fifth criticism is that even on the court's conclusions, there was very limited planning harm, essentially arising from particular ad hoc protests and fear of crime, without downplaying the significance of those local concerns. On a legal analysis, they are of not significant weight, and one is considering commensurateness of the planning harm as against the relief sought. So viewed through a legal prism, they should not have attracted significant weight, and even without considering the statutory duty, they were highly unlikely to justify the immediate disruption to the status quo, namely requiring short-term closure of this accommodation. Maintenance of the status quo is, of course, specifically recognised in American cyanamid. It tends to be the approach which is least likely to result in justice, and that would plainly have been the position here. So those are the errors on the judge's own analysis. If one then brings into play the statutory duty, this is my fifth of 5 areas, the position becomes, we say, clear beyond any real doubt. We say that proper and structured analysis means a balance of convenience emerges in a very clear way, namely there should be no relief. Now briefly, in terms of the judge's consideration of this, Somani has kindly indicated I can have 10 minutes of their time. I suspect I won't take all of those 10 minutes. I'll finish within the next.
Nice, please.
There's 55 and 56 where the judge records that he didn't have any up-to-date information about the scale of the problem. The 55 refers to the historic position in Ipswich in 2022. 56 says, well, no up-to-date information. The obvious point of that is because the judge has declined to admit that evidence. And the only analysis of the statutory duty is at 114. And it is the first and second sentences of that. So I do not say the judge has omitted to even consider it. He referred to it in paragraph 114, but there's no analysis of what the impact is of the relief on that statutory duty beyond acknowledging its existence. We say that if the judge had the intervention of the Secretary of State,
Yes, well, you've made that.
the points that we would have made, I'll very briefly identify what they are, and then I'll finish. First, accommodation of asylum seekers is a special statutory duty, and it requires a national strategic approach. We say it's special because of the nature of it. It is a duty which implements Article 3 commitments. If there's going to be ceasing of use of any hotel that requires a structured response by the Secretary of State, that will further the public interest far more than closure of in-use sites. As I've indicated, the analogy we draw with the absolute rule approach, you don't need to wait for other local authorities to come and make the injunctions. You don't need to wait for capacity to in fact be exhausted. It is enough to identify now, as Mr Justice Holgate did, that this is part of the overall national infrastructure and that the inevitable effect would be to impact upon it. We say this approach creates a likelihood of a chaotic and disorderly response to this state of affairs, and that is anathema to the concept of holding the ring. So, Secretary of State's institutional responsibility and the nature of the duty. Second point, the public interest. This is a related point, but the court should or would have recognised that the two competing public interests are not in fact equal. There is a local public interest in enforcing public planning controls within Epping Forest District Council. That is acknowledged. But the statutory duty represents the public interest of the entirety of the United Kingdom in a complex and sensitive field.
Were there only two public interests engaged?
Well, no, there's inevitably many, but in terms of the central battleground, the central conflict is between Epping's public interest and planning control.
Yes, and the Secretary of State.
So Mr Justice Holgate described it in paragraph 127 of Ipswich as a specific and highly unusual need, and that was right, and was not identified by this judge. Thirdly, the approach to criminal wrongdoing, that's also addressed in our evidence. I won't repeat my submissions on that. We say that there's no proper factual foundation for that at all. Fourth, the status quo. The court will generally seek to preserve the status quo, and the status quo at the date of this hearing, and indeed today, is that the hotel is operational, and therefore part of the structure of a part of national infrastructure under significant pressure. So the court should have been far more circumspect in reaching for the opposite, which is short-term disruption to the status quo. beyond the point at 114 about registration at local GP surgeries, no real consideration is to impact on individuals or impact in terms of relocation and how that would interact with demand elsewhere. And finally, the judge did not have the evidence for Ms Jones from a predictive basis as to what interim relief might mean in terms of acting as an impetus for further protest. That is a real consideration, a matter of judgment, but it is nonetheless weighty for that reason. Ms Jones has identified that this approach is something that runs at a risk of creating disorder elsewhere, and that was, alongside everything else, a significant factor which the judge failed to take into consideration. Drawing those points together, we say because there was an error in terms of intervention, you can simply remake the decision afresh. You can exercise your discretion, taking into account all of that material. We say that the only realistic course would be not to grant the injunction, and therefore it must be discharged.
Thank you, Mr. Brown. Mr. Riley-Smith.
My lords, my lady, good afternoon. The structure of the appellant's case is to outline in our skeleton 4 grounds: errors of law or a misunderstanding or misapplication of the evidence that we say entitles the court to revisit the exercise of discretion afresh in relation to the balance of convenience. I adopt my learned friend's submissions. Unless it would assist the court, I don't intend to deal orally with ground 2, nor with the balance of convenience, if, as it were, the court has the ability to revisit it. Instead, over the next 45 minutes, I will expand upon my learned friend's submissions in relation to deliberateness under ground 1. I will address in full the stop notice ground, which is ground 3. And again, I will expand upon my learned friend's submissions in relation to delay, that is ground 4, and the delay between the 15th of May and the 12th of August. If I may begin just by assisting His Lordship in the factual questions asked in relation to, firstly, whether the Council set out their concerns in writing. That is to be found at page 1543 in the supplementary bundle. This is an exhibit to the witness statement of Mandy Thompson.
Thank you. Letter 17th March.
17th of March, yes, my lord. And that is, as we understand it, the formal time in which the concerns were put in writing. It was noted in the court below, and the appellant notes it now. There's no reference there to any planning concerns.
Yep.
Secondly, in relation to the question of when it was actually confirmed with the council that asylum seekers would be arriving. Again, at paragraph 8 of Miss Thompson's witness statement, she references a meeting on the 20th of February. I'm instructed that was when they were told, first of all, the max, the cap was agreed, the number cap was agreed, and they were also, the council was told that planned mobilisation at that time was due to start in the week commencing the 24th of March. So it was at that 20th of February meeting. Although there had been meetings beforehand, and the intention to use it was flagged even before that.
The cap was 152, was it?
I thought it was
138, I believe. I think 138 was the cap.
My lord, if I might assist, 152 is the physical capacity of the hotel, so that was the number of people that could have been accommodated. the lower cap of 138 was the figure agreed to address the local authorities.
Thank you, Ms.
concerns.
Elliott.
In respect of that figure of 138, I've seen it in the email that the court has been taken to.
Yeah.
Is it anywhere else?
I don't believe so, my lady. I don't believe it's referenced in any of the council's witness statements. That's I can confirm that.
Thank you very much.
But I don't believe it's disputed as a
No.
point. Turning then to address ground one and my skeleton argument, if I may take the court to page 15 of it, in paragraph 46, I'm grateful to my learned friend for taking the court through and flagging elements of the learned judge's judgment where the deliberateness of the hotel's actions played a important, a factor of particular weight in the balance of convenience. And just to summarise the learned judge's findings, it was that the hotel had acted openly, in good faith. The learned judge noted that there was a genuine debate about whether planning permission would be required, and therefore there was no suggestion that the hotel's position wasn't genuine, that they genuinely believed that they did not require planning permission. However, the factor which is described as deliberate, the deliberate factor, was that despite all of those points, the hotel knew the council took a different position, and so, in the judge's language, took a stand, decided to take a stand against that. The appellant's overarching argument is that deliberateness in that sense is not a relevant factor when considering a planning injunction. It is entirely right to note that the behaviour of a defendant can be relevant, as it can go to flagrancy and degree of breach, which, as is made clear in the South Bucks case, the elements cited in Ipswich at paragraph 93, extracted in my skeleton at paragraph 47. The relevance goes to the concern as to whether conventional enforcement methods would not be effective or appropriate. And in that regard, it is important and partly to respond to my learned friend for the council's skeleton at paragraph 13. It's important to distinguish and be clear as to what we mean by deliberateness. It is right to say, as my learned friend for the council does at paragraph 11 of his skeleton, that deliberately breaching planning control could be a factor. Knowing you need permission and not applying for it, knowingly committing a breach of planning control, would clearly be a factor, and it's not the appellant's submission that that's not the case. But nor was that the learned judge's finding in the court below. Therefore, to address for the council an authority that is cited in support of deliberateness being relevant, which is the Westminster versus Davenport case, which is to be found at tab 8 of the authorities bundle. And if I may just take the court to that. And firstly take the court to paragraph 3, just to see the factual context in which the paragraph relied upon by the council is referring to. Davenport concerned a case where there had already been an enforcement notice, this is set out at paragraph 3, in relation to the use of this housing for commercial and non-residential uses. So an enforcement notice had already been issued.
Sorry, you've gone a bit too quickly. I don't
my-
know the case. that what the defendant's appellant was using a property for diplomatic purposes, or ceasing to use.
Yes, well, I believe it was historically an embassy or a diplomatic
Yes.
property. As it set out at paragraph 3, what had occurred was the issuing of the notice in relation to using that for commercial and non-residential activities.
Yes.
It was a property which had, I think, condition 2 said it could only be used for diplomatic activities. Then turning forward to paragraph 7, in that case the judge had looked at the detailed evidence of the history and use and found that there had been a number of breaches of that notice. It had been used for a variety of commercial purposes. And the judge was satisfied that the council had established a breach of the enforcement notice. And that is the context in which, if the court moves through the judgment to paragraph 24, which is the one cited by my learned friend in his skeleton, that is the context in which, as to the factors relevant to the question of staying the injunction, that the court references the repeated deliberate breaches as being relevant. So there is no dispute that a deliberate breach of planning control, deliberately frustrating planning control, can be a factor. But that is very different from a landowner, such as here, such as the hotel, who has a genuine reasonable belief that there is no breach of planning control, and deliberately, as it were, relies on that belief. That, we say, cannot be a factor in support of an injunction, either an interim or a final injunction. Especially where we don't have a case such as this, where it is a clear-cut operational development, the construction of a building without permission, but a finely balanced planning judgment, which, as I noted earlier, the learned judge below recognised there was genuine scope for debate. And the reason that is the case, the deliberateness in the way in which the judge found against the hotel and I have defined it, the reason that cannot be a factor is twofold, we say. Firstly, it doesn't have relevance to the context in which the behaviour of the defendant is relevant in planning injunctions, which is that it gives rise to a concern that conventional enforcement will not be an appropriate remedy or approach. In Great Yarmouth, the case of Great Yarmouth, that was a case where an enforcement notice had been issued back in 2006. And Mr Justice Holgate, as he then was, noted it gave him concern that that had proved to be ineffective in controlling a breach of planning control to a hostile use. But a landowner having a genuine reasonable belief and relying upon it cannot and should not give a court a concern that if conventional enforcement methods were used, they wouldn't be effective. And the second reason why the appellant says deliberateness in this sense cannot be a factor is with respect to the learned judge below. It fails to recognise or grapple with a fundamental point in the planning system of this country, which is there's no requirement or obligation or duty for a landowner who has a belief that a use is lawful to test that proposition, either by applying for a planning application, which in itself wouldn't sit necessarily right with the belief that no planning permission was required, or by applying for a certificate of lawfulness. A certificate of lawfulness in the planning system does not establish lawfulness. What it provides is conclusive proof that a use is lawful, because it doesn't require permission. But you do not need a certificate of lawfulness to have a lawful use. And therefore the appellant, like any landowner, was entitled to conclude that permission was not required, a position which was informed by the Home Office, advice from the Home Office themselves, and rely on that. And critically, and with respect to the judge, the element that might have been overlooked in the learned judge's consideration of this issue is that, of course, it doesn't leave that position of, to use the judge's language, the landowner taking a stand, although I'll come to why we respectfully disagree quite with the inference that raises. That doesn't leave a local authority in any way powerless. They have the range of conventional enforcement methods that can be used. And of course, if they are used, can be appealed on grounds that no permission is required, or alternatively, that permission should be granted. And as the learned judge's concern was that the appellant had sidestepped public scrutiny, it is relevant that conventional enforcement methods allow for that public scrutiny. An appeal, a planning appeal, an enforcement appeal is a public process. And the effect of the learned judge's conclusion is to wrongly place on the landowner a burden not only to be upfront and honest, because that is what the hotel was with the council, but to be proactive and proactively test their case with the council. But in fact, in the context of a planning injunction, in this forum, the question and any criticism or detriment that flows from that question in the balance of convenience should not be towards the appellant, why didn't you proactively test your honest and open belief? But instead should be to the council, why, when you knew that the appellant, when you knew the landowner had this belief and were taking a stand, why did you not enforce against that as the planning regime would envisage that you're able to do? And so the hotel would respectfully dispute that in the connotations of a sort of aggressive, confrontational way of taking the stand. We would say that instead the appellant was relying upon a genuine, reasonable judgment in a finely balanced, complex question, that there was no material change of use and they didn't require permission. That shouldn't be a factor against them in the balance of convenience, but on the learned judge below, not only was it a factor, it was a particular factor. I think it appears second in his factors, and the judge says at the end it's the first three factors that were particularly weighty in his mind. And so that, we say, is an error of law. Unless I can assist the court any further on ground 1, I'll turn to ground 3, the stop notice ground.
Yes.
Starts at paragraph 69 of the appellant's skeleton at page 20. And this is a discrete matter of statutory interpretation. That we say that the learned judge was wrong to find that the respondent was unable to serve a stop notice due to the operation of subsection 5 of section 183. If I may first, before
Suppose they had. How would matters have gone from there? What can you do if you're a landowner on whom a stop notice has been served?
Yes, my lord. So a stop notice accompanies an enforcement notice. They're paired together, and it requires that activity to stop. It cannot be appealed. It can be challenged by judicial review, but there are no appeal rights against a stop notice. It remains in force, preventing that activity carrying out, either until the notice is withdrawn, or the notice is quashed on appeal, or, if a notice isn't appealed, the period for compliance ends. The reason being, at that point, a new criminal offence arises.
Sorry,
Yes.
Until the enforcement notice is quashed on appeal.
Yes, so as well, when the notice is quashed, if an enforcement notice is quashed on appeal, the stop notice
Yes.
ceases to have effect.
So your only remedy would be to apply for judicial review and to say, for example, if it is the case, you were too late to issue a stop notice because this has been going on for 4 years. I don't want to go into the rights and wrongs of that contention, but I'm just looking at procedure.
Yes, my lord. The only case that is not before the courts, it didn't assist on the point, references whether subsection 5 can be used in a defence to criminal proceedings. But yes, your lordship is right. Another way in which it could be used is on a judicial review of saying you were too late.
Yes.
The other ground could only be the conventional public law grounds, but you're challenging there the discretion of a local authority to consider it expedient. So it's not a de novo merits consideration, as would be on an appeal.
No.
The effect if a stop notice is breached is it's a criminal offence. And just to make the court aware, within the regime there's also what's called a temporary stop notice. It does the same thing. It can be issued before an enforcement notice and it lasts for 56 days. The restriction's the same as well on the 4 years. But it isn't the case that a council can only do a stop notice when they issue an enforcement notice. There's an ability to issue what's called a temporary stop notice before an enforcement notice is issued. And the real relevance of the existence of a stop notice, it's not the appellant's case that it determines matters either way. If it's available, it means an injunction should always be refused, and if it's not available, an injunction always granted. But what is a factor in the balance of convenience and in the question on a final injunction is if there is a conventional enforcement tool available which could secure the immediate cessation of an activity if the council conclude that they can't wait for any compliance period on a notice to end or for the appeal process to go through. Importantly, what a stop notice though also does is it allows for issues of planning control, whether there's a breach of planning, whether there's unauthorised development. And it allows for issues of planning merits to be dealt with in the appropriate forum. A planning appeal against an enforcement notice in front of a planning inspector, rather than the route of an injunction which requires the court to engage with some of those issues. And we would respectfully say is not the most appropriate forum for planning issues to be considered. So that's the relevance of the availability of a stop notice. We say it should be preferable in the sense that it allows for matters to be kept in that appropriate forum of an enforcement appeal if one is made, and the public process of an enforcement or planning. What's relevant?
Speaking for myself as a layman in these matters, this doesn't seem to me a very attractive point. You're saying that the council were wrong to apply for an injunction. They should instead have adopted the even more drastic remedy of issuing a stop notice. Says from this day onwards, or I don't know whether they can be deferred, but anyway, from this day onwards, you, the hotel, will be committing a criminal offence if a single asylum seeker is resident at the hotel, and your only way of challenging that is to go to the High Court and seek judicial review, and goodness knows how long that will take.
My Lord, I would say that there are two, as it were, reasons why that route can bring other benefits for a landowner. The first is it being in the correct forum. The second being that there are statutory compensation provisions that arise with a stop notice. That if a council has been incorrect in doing so, the landowner is entitled to compensation.
And does it take immediate effect?
My Lord, a stop notice can typically takes effect no earlier than 3 days, but in circumstances where it is believed appropriate, it can take immediate effect.
Yes. Well, anyway, we are concerned with the judge's decision on an interim injunction.
Yes.
He may or may not be right to say that it was too late to issue a stop notice, but in my present view is that we should work on the basis that at least arguably he was right.
My Lord, I'm grateful for that indication. If I may just perhaps address the relevance of it to the question before this court, and then see.
All right. I mean, if you were going to say the stop notice issue feeds into the question of delay, that if the judge, suppose for a moment the judge was right and it was too late, you might say, well, that's not an attractive point in the council's favour to say we need an urgent interim injunction, and the reason why we couldn't issue a stop notice was because we've tolerated this position for 4 years.
My Lord, that is a point. I would respectfully go further as to why the learned judge's error that a stop notice wasn't available to the council is a factor, because one of the questions for a court in a 187B injunction is whether conventional enforcement methods would not be appropriate. And the issue is that if the appellant is right and a stop notice could have been used, there's no evidence that, first of all, the council turned their minds to that conventional enforcement method because they were told it wasn't available to them. And that in turn raises a question in the balance of convenience as to why the more exceptional remedy of a planning injunction is being used over the more conventional approach where there is a concern of urgent planning harm, of issuing an enforcement notice coupled with a stop notice. That failure to consider that point, we say, is a factor that supports refusing of interim relief. But given I want to make sure I valuably use court time, if your lordship or the court would not be assisted by me expanding on those submissions as to a matter of statutory interpretation, I'll move on to ground four.
No, I don't think we would.
I'm grateful for that indication.
Delay.
Delay. The fourth ground of error relates to the judge's findings based on the evidence before him in relation to the period of time between the 15th of May and the 11th of August. And this is dealt with at paragraph 85 of the judgment, which is found, I think, on the core bundle the court has immediately before it, I hope, on page 73. I'll use the Secretary of State's core bundle reference. And hopefully 73 should take the court to judgment paragraph 85.
Yes.
And the learned judge had noted that delay is relevant and that there must be no undue delay in coming to the court for that relief. And noted in this period from when the respondent was, when the council were clearly informed that no permission would be applied for, that the judge was satisfied that it had come to court as a last resort after other forms of persuasion had failed and after its concerns had been heightened. There was also a finding on the evidence that there was no suggestion that the claimant caused the defendant to believe that it has in effect accepted its case. However, with respect to the learned judge below, dealing first with the first of those conclusions, that it had come to court as a last resort after other forms of persuasion had failed, the unchallenged evidence before the court below and this court was that from that 15th of May notification, there was no communication at all from the council's legal or planning department raising a concern about the alleged breach of planning control. The court is given in my learned friend for the council's skeleton at paragraph 31 a number of paragraph references within the witness statements. However, nowhere do those paragraph references evidence or show the council contacting the hotel about the breach of planning control.
Well, paragraphs 31 to 34 set out communications, of which the last is 15th of May.
Yeah.
It's not suggested anywhere, is there, that there was communication between the council and Somani after the 15th of May?
Yes.
Yes.
And why we say that is particularly pertinent, before we come to the length of time, is there's no explanation or reason that the appellant can see why, because there's reference there to the recent circumstances being the protest, the council could not have said to Somani that these protests are the tipping point now. You know we've long considered you to be a breach of planning control. You disagree, but stop. Stop, or tell us why you think you're right, or put in another retrospective application and we'll determine it quicker this time, or put in an LDC application to placate these protests, or we're going to enforce, or we're going to injunct. There were numerous potential communications that could have been had, and we would say you would expect to have before the exceptional step of this injunction was sought. And in absence of any communication with respect to the learned judge, we don't know how it can be said that other forms of persuasion had failed in relation to the hotel stopping its use. The second element of paragraph 85 of the judgment that the appellant takes issue with is the finding that there was no suggestion that the claimant caused the defendant to believe that it accepted their stance or regarded the use as acceptable. And in that regard, it is important to note that in the 15th of May email from the appellant to the council, informing them that an application wouldn't be submitted, it was referenced that a local authority engagement officer, I won't read out her name simply because I don't think it's necessary to do so, but the local authority engagement officer agreed that the various asylum accommodation was contracted as exclusive use hotels, not hostels. We have that, which I appreciate is not coming directly from the council, it's coming from the hotel back to the council, but informing them, and I don't think the council take any dispute, that that was something that the hotel had been informed of by this engagement officer. And we then have 3 months of silence and inaction from the respondent. And we say that entitled the hotel to have a understanding that in terms of the planning concerns that the council had, which had been expressed before that day and had intermittently been historically expressed, were no longer a concern. 3 months is a long period of time when viewed in the context of an urgent application that was informally served on the Monday and required a hearing on the Friday. And we would respectfully submit that the learned judge was wrong on the evidence before him to find that there had not been undue delay. And
where is the letter of the 15th of May in our
yes,
bundles?
it's in the supplementary bundle, and it's
SB 156.
I'm grateful to you.
Thank you very much. Oh, yes. Thank you. Yes.
My apologies, my lord, for not having that reference at my fingertips. And given the learned judge was in error on the evidence before him to find that there had been no undue delay, if there was undue delay, then that is a further factor that should have been in the balance of convenience, supporting the interim injunction being refused. And my lords, my lady, just in the remaining 4 minutes that I have, if I may just end on this point, which does in part go to submissions on the balance of convenience. A planning injunction is an exceptional step. And unless you can't use conventional enforcement methods because there is an anticipated breach, and to answer, I think, a confusion your lordship had in relation to the reference at 114 of Ipswich. As I understand it, Ipswich was before they had actually moved in. I think that's why it's referred to as an anticipated breach of planning control.
And you can't issue an enforcement notice
Against until it happened. I think in Fenland they had moved in. I think in Great Yarmouth they had not. I think is the right way round. So, where you can use conventional enforcement methods, such as in this case, it is an exceptional step and one reserved for the most serious of planning harms that justifies immediate restraint by order of the court. And in that context, the fact that this use had been occurring since May 2020 and had currently been occurring since April 2025, we say brings that question into stark relief. What is the immediate, urgent planning harm that in the context of interim relief means this can't even wait for a final hearing? I appreciate the council didn't know it would be October when they applied, and the court now does know it will be October. But that is a particularly stark question in the context of interim relief and in injunctions more generally. In that context, as the learned judge below found, there's no specific planning policy reason that's being breached, such as in Great Yarmouth. In this case, there were two highly generic policies which the judge gave no weight to. And really, the appellant would submit in its concluding remarks, what this comes back to, and I won't tread on the toes of my learned friend for the Secretary of State, but what this comes back to is seemingly it was the protests that triggered the change in position, that a long-standing use of the Bell Hotel had to be immediately restrained through planning injunction. And just as a headline point that is set out in my skeleton, we'd respectfully submit that a protest cannot be a weighty planning harm, such as to justify a planning injunction. The planning system itself can't control or regulate protests. And we would say it would set a dangerous precedent if it could do. And note, given the change in circumstance that seemed to trigger this application was the protest, the judge below did note that these were factors that carried limited weight. So if it really is the case that it's the protests that justify the injunction, even on the learned judge's analysis below, when the other factors which we've discussed can be discounted through others of law, the protests cannot carry sufficient weight to justify that exceptional step. Before I turn my back, may I just check if I can assist the court any further with any points?
Not on matters you've actually been addressing the court on, but on a matter of fact, Elliot wants to help, all gratefully received. In paragraph 8 of his judgment, the judge appears to make findings of fact. And it's really the second one I'm looking at. From May 2020 to March 2021, the bell was used to accommodate homeless persons, including asylum seekers. It's probably my fault, but I haven't been able to find the source of that information.
Yes, if I may just turn the back, my back.
You don't have to give it immediately if you want to give it
No, well,
short
I think I know the answer.
Right, fine.
Yes, the reference to homeless persons is incorrect. It was always just asylum seekers.
Right. In respect of just asylum seekers, he makes the finding at 8.4 that from October 22 on, for a substantial part of that period, those asylum seekers were predominantly single adult males. I have seen the evidence relating to the 24-25 contract. I've seen evidence from February 23. Again, where is the evidence there that the judge is actually relying on?
My lady, if I may just... I again think I know the answer, but I'll just confirm it.
Sure.
Before. It's a I won't say his name. It's a paragraph in the defendant's witness statement. I'll just get the paragraph itself.
Just give me the paragraph.
Yeah.
Or you can do it after the short adjournment so as not to take up the court's time now.
I mean, briefly, paragraph 8 of the judge's judgment is agreed to be correct, save for deleting homeless persons including under subparagraph 2, then we'll take it from you all that it's correct. If it's said to be factually incorrect in some other respect, then we'd like to know about it. But you don't need to give an answer to it at this moment.
I'm very good. I'm told that the reference in the witness statement is paragraph 20.
Thank you.
The one thing I just... I think the point I was just clarifying is there's a reference in 8.4 to predominantly,
Yeah.
and I think it's always just been single adult males during that period of time. I don't think the predominant. I'm not sure it makes a material difference, but I don't think it's predominant. I think it was always just all single adult males.
Thank you very much.
If I may just turn my back.
Yes, of course.
Thank you very much.
Mr. Cobb, would you like to start now, or would you prefer to start at 10 to 2?
My lord, forgive me.
Would you like to start now and give us a preview, or would you like to start at 10 to 2?
I'm content either way, my lord. My lord, may I just say I'm Mr Green, not Mr Coffin.
I'm so sorry. Yes. So you are. What's happened to Mr. Coffin?
My lord, he has an unavoidable commitment, I'm afraid.
Well,
He could not.
that's all right. No, just an advocacy slip has his name at the top of the list. Well, I'm so sorry, Mr. Green.
What's wrong, my lord? I'm content to start now or at 10 to 2.
Well,
whichever.
why don't you start now? Give
Okay.
us a brief preview of what's to come.
My lord, I'm going to start with the Secretary of State's applications for permission to appeal. And I produced a separate skeleton argument for that.
Yes.
If I can take the court to my skeleton argument, paragraph 7, I set out what in my submission is the correct approach in an appeal such as this. It's taken from paragraph 44 of the better case that this court was taken to earlier, and I don't understand it to be contested. So, paragraph 7 of my skeleton argument in the Secretary of State's appeal.
Yes.
Whatever view members of this court might have of the judgment below should not with respect interfere unless there is some identifiable error in it.
Yes.
Paragraph 9 of my skeleton argument, I set out the case law, summarising what is in the better case, again, which this court was taken earlier in the day by Fred, and I would emphasise the third bullet point there, taken from paragraph 37 of the judgment that this court looked at earlier. A third party will not be joined unless it's desirable that he should be. This operates as a control mechanism to ensure that a third party is not permitted to gatecrash proceedings in which he has no legitimate business, where his presence would unduly complicate or add to the cost of the proceedings, or, and I would emphasise these words, or where his presence would add nothing because the relevant issues are being contested by the existing parties. And in my submission, it was on that rock the Secretary of State's application found.
Sorry, on which rock?
The parties, the hotel and the council, were already contesting the issue of the weight to be attached to the Secretary of State's duty to house asylum seekers. That was already an issue. There was no need to join the Secretary of State for that matter to be ventilated.
You've used the word need there.
Because that is how it was put in the court below by the Secretary of State. Can we turn very briefly to the oral judgment? It begins at tab 8, page 45, and at page 47, paragraph 8, Mr Justice Eyre summarised the case presented by counsel for the Secretary of State. In terms which thus far have not been criticised by my learned friend.
You make this point in your submission, in your written submission. I
Yes.
have it. And that's why you say when the judge goes on in the opening sentence of paragraph 15, say it's not necessary, he was simply using the word that Mr Brown had used in the argument.
Yes. But he goes on, by to say, nor is there an issue which means it would be desirable.
Desirable. Yes.
Well, that's the more important issue, speaking for myself. Whether or not it was necessary, and perhaps it wasn't necessary.
Absolutely.
Was it desirable?
Was it desirable? Which brings me to the third preliminary point. As this court is aware, there have been 4 cases, not 3, in the bundle of authorities. Ipswich, East Riding of Yorkshire, they were heard together, Fenland and Great Yarmouth, in which injunctions were sought on an interim basis against hotels accommodating asylum seekers. In none of them was the Secretary of State a party. In none of them did the Secretary of State seek to intervene. It is true that the defendants in those cases included the contractors engaged by the Home Office to secure accommodation, but in none of them was it thought necessary for the Secretary of State to be joined as a defendant or an intervener. And yet, evidence on the part of the Home Office was presented in each of those cases.
How? Just give me, you don't have to take me to the
Witness
judgments.
statements, my lord.
But,
Witness statements were put in by
by-
officials working for the Home Office,
Right.
giving evidence about the workings of the system
on behalf of.
on behalf of the defendants.
But the reality of the situation is that the service providers, in this case CTM, are working closely with the Home Office in a way that the hotel simply isn't. That is the reality of the situation, is it not?
Although I don't have evidence on that, my lady, that it certainly appears to be the situation.
Well, isn't that borne out by the tripartite discussions that were taking place certainly in February of this year? They were between the Home Office, they were between Epping and CTN. The hotel wasn't playing any part in it.
I can't speak to those particular discussions, but I do understand that CTN in this case is acting as, I suppose, the agent for the Home Office and will have closer contact with the Home Office than the hotel. That would make sense.
Yes.
And we can see that CTM in this case did provide the hotel on the 13th of August with an email setting out answers to a number of questions. So they would certainly, I suspect, know more, but in each of the 4 cases that have already been decided in 2022, evidence was given by Home Office officials in witness statements to assist the court. And there is nothing in my submission that prevents that from happening in this case. point which the judge below was alive to.
Well, he said, in effect, the Home Office had plenty of time to get into this case, and it's their own stupid fault that they didn't. I think that's a fair summary, isn't it?
Well, yes. If evidence is needed from the Home Office, it can be put in.
All right, shall we
Well,
break
that's
off
convenient.
at that point?
Yes.
Right, 2 o'clock.